Hello, my true crime lovelies. How are you? I've chatted with a lot of you guys today. It is September 3rd, Tuesday. I was in a lot of chats rewatching and watching the Sarah Boone hearing with her new attorney. And so I just wanted to come in and give you my 2 cents. I thought, well, let's overall, I like where this is headed. Let me say that. Overall, I like where this is headed. I have a few nitpicky things, but overall, I am just more in love with Judge Cranick, and I'm not just saying that because he's sitting over here behind me. He's amazing. What else can I say? Yeah, so, and we may have to change up the break room. The ad has been answered, so we might have to replace that with something else. And then maybe a few other people should join us in the break room. Should we add like Cashman? We'll see. But anyway, let's get into this. I'm waiting on groceries to be delivered. I'm giving you a warning. The baby is asleep. The dogs are asleep. Depending on if the delivery guy follows the directions, the dogs may wake up and want to get to the door, and the baby may also wake up. So we'll try to make quick work of this. Let's get into it. I backed it up a little bit so we could see Miss Boone walking in. And here she goes. She's backshackled because she's got an attorney, but look at that face. Chester cat grin. I don't think I've seen her teeth in court since this all started, so she's smiling. She almost looks post-coital to me. She's flush and giddy. I don't know why she made that stink face right there, but it just is giving post-coital. So, the foreplay and everything else must have been good. And honestly, like, just to be fair, I feel like it's good to be happy. It's good for your mental health. If she had been happier more often in her life, we probably would not be here where we are. So I don't begrudge.
Judge, I'm James Owens, and I'm representing Sarah Boone.
Sir, good morning. Pleasure. Ms. Boone, good morning. Could you please state your, raise your right hand now. First, going to go ahead and swear you in.
Do you solemnly swear or affirm that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
Yes.
Ma'am, good morning. Could you state your full name and date of birth for the record for me?
Sarah Boone, 101077.
Good morning, everyone. We are here on several different items. The first is the court's notice of hearing that was sent out last week. The first issue on that was addressing the viewing of the physical evidence here in open court. On August 5, the court entered an order setting forth certain deadlines and scheduling, including the viewing of the digital evidence no later than September 3, and the physical evidence viewing to take place here in open court on September the 3rd, and a schedule for objections thereafter. The digital evidence review took place on August 9th, and the August 23rd deadline for objections has since passed. On August 14th, the court was advised of an alternative arrangement and advised the state to file a notice reflecting when and where and how that review would have taken place. I did not receive or see such a notice in the court file. Mr. Cashore?
Yes, Your Honor. We were not able to file the notice prior to today. However, on Friday, August the 30th, we were able to have that evidence review of the physical items with Ms. Boone at the Orange County Jail.
Okay, all right.
So Chicken Cacciatore is alone today. Well, he's not alone. He's without Mr. J. There is a young woman seated at the table. I'm not sure if she's a lawyer or law clerk, but she seems to be taking notes. And what they just discussed, we talked about this last week, is they were meant to view the physical discovery today if they had not had their private meeting and filed it with the court previously. So they got half of it done. They had the meeting on Friday, probably went late until Friday, I'm guessing. And then everybody went off to enjoy the long 3-day weekend, and they hadn't filed it because they were, unlike James Owens, they were not furiously making filings this weekend. They were hopefully off enjoying their Labor Day weekend. So that has been completed, the physical evidence has been reviewed, and they're going to state on the record it was with Sarah and her investigator, Billy Lane. The new attorney was not there.
Ms. Boone, can you confirm if in fact that viewing took place?
It took place.
Okay, all right, very good. And who did it take place between the state, yourself, and was Mr. Lane with Prison Break Investigations a part of that viewing?
Correct.
Okay, all right, thank you very much. Also set for hearing this morning was defendant's motion for payment of costs and appointing neuropsychologists to assist the defendant in preparation of the defense that was filed on the 14th. The next day, August 15th, JSCS filed a response to the motions for payment of costs and appointment of a neuropsychiatrist. Paragraph 10 of the JSC's response reflects that the JSC will not be participating in this hearing. Mr. Owens, good morning. What is your position, sir, with regard to Ms. Boone's pro se motion for costs? Are you adopting that motion?
I'd like to abandon that one, but substitute it in for two other motions for the appointment of a forensic psychologist, Dr. Julie Harper, who was on this case previously. I believe she saw Sarah Boone about 6 times at the Orange County Jail. She was working under the direction.
So Julie Harper, we talked about her, I think, on Saturday, or it might have been yesterday, but she was originally engaged by Mauricio Padilla, and so she has already met with Sarah. We went through the list of all of the people that she had met with in the motion, so I think that's a good play. They already, we can shorten that trust building time that he was looking for. They've already met, they're acquainted with one another, and so that's good. And then this is the new attorney. You're kind of, we're only seeing the back of his head. I will say he is older than the pictures that I've been using from his website for him. Maybe 10 or 15 years older, but he's super energetic. I feel like he's definitely older than I am, because I think when he started practicing, I was like in the 9th grade. I would just say, as a person in my 50s, I'm a little more energetic than other 50-year-olds. So whatever age he is, like 60, he's a little more energetic than most 60-year-olds, which I like that. I like his spunk, and that he's coming in and owning it. Do you know? Like, he's stepping into it 10 toes deep.
The original counsel, Mr. Padilla, who I believe had the case for about 2.5 years. And I think it was set for trial, ready to go, and then at the last minute he withdrew. I tried to call him a couple of times, haven't been able to find out what went on. I have talked to Ms. Cashman, the last lawyer, but we don't need this neuropsychologist that Ms. Boone had requested, but we do need a reappointment of the forensic psychologist, Dr. Julie Harper. I've spoken with her a couple of times last week. I text messaged her 4 or 5 times this weekend. She is in agreement to handle the case, to reopen her file. She has sent me her records. I have reviewed them. I've met with my client. I think my client meets the criteria for that spouse. I believe Dr. Harper, after she gets a chance to re-engage with my client, spend some time with my client, and hopes that she's going to be of that opinion. In addition, I believe it's necessary for the appointment of a crime scene reconstructionist and death investigator, Dr. Michael Berkland, who is from my area, Pensacola, is who I am recommending to be appointed.
What was his name again, sir? I'm sorry.
Michael Berkland. I filed these judges yesterday or last night. I don't know if they're in the court file yet.
I did not see them this morning. I did see the motion to dismiss.
Can I post them in?
Yes. State, have you seen them?
I just saw them briefly this morning prior to the hearing.
Thank you. The only thing I saw in the court file, counsel, when I was prepping last night was the motion for statement of particulars, the column September 2. I have not yet seen these motions.
Judge, I also filed a motion for additional discovery. I don't know if that made it through as well.
Was that also filed yesterday, sir, sometime in the evening?
It was filed at 8:30 yesterday morning.
So I have your motion for statement of particulars filed 8/10 yesterday, but I do not have the motion for additional discovery filed 8/34.
I don't know why, the court was not able to post that, because they were filed one right after the other.
One's in the court file, the other three aren't.
One of the days,
They were all filed yesterday, 19.
no, certain things auto-populate and certain things have to be accepted.
Okay.
The statement of particulars and the additional discovery were filed yesterday morning. The motion to appoint the crime scene reconstructionist and death investigator, and the motion to appoint the forensic psychologist was.
I don't know if you heard the clerk, but she said certain things will auto-populate, so the filing will just be accepted, and other ones you have to manually go in and accept because they're going over. Owens is stating he submitted everything at the same time, and she's explaining even though it was submitted that way, it won't be recorded that way because she was off, and so she wasn't in there manually accepting things, and I'm mad at her.
Filed at 6:10 p.m.
I do see that. As the court previously identified, JCS chose not to participate in this morning's hearing by virtue of their response filed on August 15th. They're not here. Your motions for these various experts report that they were sent to all persons on the service list through the e-portal. But I don't know how I can address these this morning without having JCS here. So I will endeavor to coordinate a hearing for these as soon as practical. I understand these need to be addressed. Be advised, this is a trial week for the court, as is next week, but I will do my best to endeavor to try to get these heard as soon as possible.
And the fact that he didn't email JACS, that might be an outsider move, because everybody else that I've seen in this case, in this filing, I'm not a lawyer, they've always emailed them, because I mentioned that was going to be a challenge for Sarah since she can't email. And either the JAC will come back and say, we don't have a response and use this email for that, or they'll say that they're going to appear. And so it sounds like he only filed it in the portal. The portal did not self-populate this, so they didn't see it. So that's why they're not there. Because they had already responded to the neuropsychologist motion that was pending. Well, not already. As part of prepping for today, they had responded on the docket. And so hopefully someone will bend his ear and say, hey, here's the email address to send these things to us. He doesn't have to, it's not required, but obviously it would be faster for him and his client.
Judge, and I filed my notice of appearance on Friday,
Yes.
and I've spoken with Dr. Brooklyn 2 or 3 times this weekend. The state was able to provide me with some discovery. I think once I filed my notice early Friday morning, I think the state provided a lot of discovery to me. I provided that to Dr. Brooklyn. I believe he has the autopsy. We cannot find the autopsy photographs, which he says are critical. We cannot find the crime scene photographs, which he says are critical to his evaluation. So I know time is of the essence. We've got people working on it, but there is some additional evidence that we need.
State, what's the status of the provision of the autopsy photographs and the crime scene photographs and provided to counsel?
We provided all of those things previously, obviously, to the defendant, which has been greatly discussed already. When Mr. Owens' notice of appearance came on the case, I instructed my assistant to go ahead and send copies of the document discovery, which is easily available to him, just so that he could quickly have that and not have to worry about getting that from his client or whatever. I believe we also sent notice to as well that if he wants additional copies of the autopsy and crime scene photos or any other pieces of digital evidence in the case, that he just needs to provide USB and he can go ahead and burn that for him. Again, this is in addition to what's already been provided to the defendant in this case.
Okay, do we have a time frame where we might be able to get that information to him?
He wants to come back to my office, we can do it this morning / this afternoon.
Is your office in the building?
Yes, it's in the courthouse.
Right there. Come out front door, make a left.
Okay. I don't have a USB with me, but I'll find one. This morning, we'll get that done.
Okay, I appreciate you both. With regard to the motion for additional discovery filed yesterday, September 2, 8:34 a.m., state you the opportunity to review this.
I just reviewed it just now here in court this morning. The state was at a request, an opportunity to respond to both this motion and also the motion to the statement of particulars formally and in writing, given the lack of time we've had to prepare to make a quick formal response.
Sure. And how much time, Counselor, would you like in order to file a response to the motion for statement of particulars and the motion for additional discovery?
I would ask for at least a week.
Any objection?
No objection.
Okay, all right. The state.
I'm doing commentary, so if it drives you crazy, if you see at the top of the screen, live suitcase murder trial, motions hearing on law and crime, you can head over there for it. But I also want to say this attorney seems to be big on press. So he, I guess, has also signed up for rehabbing Sarah's image. So while I like to think she's smiling like the cat who swallowed the canary because she got her surprise up, on the prosecution and the judge, in her viewpoint, I'm saying from her perspective, because she showed up with an attorney or he filed, you know what I mean? But I wonder if he's also telling her, you have RBF. So maybe smile a little. I hate when people say that to a woman. This is, unfortunately also about perceptions, and she needs to be perceived as a kinder, gentler woman to overcome that video where she's like, F you. So do you know what I mean? I think that also might be a part of it. So she's like giggling and being lighthearted. I think that is intentional.
Shall file a response to both the motion for statement of particulars and motion for additional discovery no later than the close of business 5 p.m. on Tuesday, September the 10th. And if hearings are necessary, we'll coordinate those. With regard to the defendant's pro se motion for payment of costs and appointing neuropsychologists to assist the defendant in preparation of the defense, the court's going to deny that as moot based on Mr. Owens' representation. With regard to the motion to appoint crime scene reconstructionist and death investigator and motion to appoint forensic psychologist, State, are you intending on filing a response to these?
No, we're going to take no position on those points.
Okay, all right. I will have Ms. Barrios, I'll ask the clerk to see if we can push these through the portal today so that Ms. Barrios can reach out to JICS and see if we can get a time frame on when they may be able to provide a position statement or a response to those motions, and then we'll coordinate a hearing respectfully.
Judge, I'm going to want to add one other forensic psychologist, make a request. I want to make sure that there's not an issue about my client Sarah Boone and I manufacturing the defense. And there's a second doctor, Dr. Michael Brannon. I'll spell that out for me, sir. Dr. Michael Brannon. I don't know.
B-R-A-N-N-E-N?
He spells it B-R-A-N-N-O-N. He was the forensic psychologist in the Marsha Thompson case. That was the Palm Beach County first-degree murder where she shot and killed her husband. Shot him 9 times. He was laying on the couch and was acquitted of first-degree murder back in July of this year. That was a 2019 case, so that took a while to get to trial. But Dr. Brannon testified that a battered woman's experiences affect her perception of imminent danger. And that's going to be a question in this case, whether or not Sarah Boone, at the time of her actions, was facing imminent danger. In addition, Dr. Brannon said victims of repeat violence may fear death in situations others would not.
And?
I've tried to reach out to Mr. Brannon this weekend unsuccessfully. And my intent is to reach out to him. I'm hoping he's going to respond. He claims on his website that he responds within 48 hours. I will be, that's the only other witness I'm going to need an appointment for a forensic psychologist. So
I have a clip that I'll show you guys, but because we blew up that Owens was going to be representing her on Friday, he might be like not answering his phone for Owens. I don't know, but I'll show you what he had to say. He obviously hasn't met with Sarah, so he said in very generic terms what his thoughts were, and then I did some Google searches that I want to show you guys.
forensic psychologist, Dr. Julie Harper, Dr. Michael Brannon, and then the crime scene reconstructionist, Dr. Michael Berger. And then in addition, I would like Billy Lane, who's seated in the audience. He is the investigator on the case. Because of the claims that we're making, that she's a battered woman, we need evidence to corroborate that. So there's a lot of history between her and Mr. Torres involving the apartment complex, which is in Winter Park. That was 4 years ago.
That gum must be
The
good,
ownership
Billy.
of that apartment complex has changed hands, so it's going to be somewhat problematic trying to get information about who all the tenants were that may have witnessed some of the violence involved in these two, as well as we're trying to get together the 911 calls that Sarah made and others made about the disturbances between that couple. So he's got a lot of work to do as it relates to running down witnesses. In addition, we're trying to get arrest reports of the prior domestic violence arrest of Mr. Torres, as well as the officers involved and their body cams to see if there's any evidence on the body cams that would show injuries to Ms. Boone. So we've got a lot of work to do, but I believe it's necessary for us to prove a viable defense of battered spouse syndrome, that we have cooperation. It's going to take a little bit, but I do need the appointment of that expert. He tells me he's already on. I'm going to have to file something else because it was under Sarah Boone. Now, as the attorney of record, I'm going to have to file something. He says he's still got plenty of hours to work under that original cap. So I'll be filing something today or tomorrow as it relates to that. But that's the only other, of course, I've been retained, so I'm not going to make any claims for attorney's fees. I'm not making any claims for travel costs, just for these witnesses.
The JCS has already approved, I believe, $10,000 in investigation fees and $1,000 for other costs associated with Mr. Lane. That was at one of our previous hearings. Now, that was when Ms. Boone was representing herself pro se. I can't imagine JCS may change their position with regard to those costs. They've already said yes, but file it and we'll try to tee it up for hearing as well to see if they have any position, or it can just be, the order can be modified to extend to you as counsel for Ms. Boone.
Thank you.
All right. That takes us now then to your motion for continuance file that was filed on August 30th. Court's had the opportunity to review that motion. Any other arguments or statements with regard to that motion? Mr. Owens.
Judge, I reviewed the state case law relating to continuances and the abuse, palpable abuse of discretion when the court does not grant it. But it is critical to my theory, our theory of defense, battered spouse syndrome. As you know, that takes time to develop, especially when the motion basically speaks for itself, but we're in a time crunch. Essentially, the trial is set for October the 7th. I have to provide a notice of intent to rely on battered spouse syndrome 30 days prior, which is September 7th, which falls on a Saturday, so I believe that gives me till the next business day, Monday, September 9th. But still, 6 days for Dr. Julie Harper to come back out and visit with Ms. Boone, coupled with this other potential forensic psychologist, Dr. Michael Brannon. He's not going to have time to do that. They've got to establish a rapport with her before they can run the testing, spend the time with her. And it involves some extensive history. Obviously, that couple was together for 3 or 4 years. I still haven't peeled back all the layers. I've tried to go through it, but as you know, something like that is going to involve several instances of domestic violence that did not involve law enforcement. That was just between the two. So we've been going through that We're trying to get some medical records where she was stabbed by Mr. Torres in the leg, and some other evidence. It's just going to take some time, coupled with the fact that I've got to get Mr. Lane to get all this other objective.
So now we know why she wanted her medical records, right? That was in that 58-page letter, which she had been, I guess, asking Miss Cashman for it, and then finally sent the letter to the judge. So she wants that stabbing thing. I'm not sure when it was, if anybody knows. I remember hearing Brian Boone's audio, and he mentioned it in there, but how long ago was that? I mean, I'm not justifying it. I'm just trying to get a time frame. And I believe they got together in 2017, at least looking at what Sarah says in the first, what do you call it? Police call. But I'm interested, somebody here knows. I'm crowdsourcing. If you guys know, let me know, please, because I'm super curious. If it's 3 years, 4 years, 3.5.
Evidence, witnesses, and 911 calls and arrest reports, and provide that to the two forensic psychologists for them to help formulate their opinion as to whether she is, in fact, a better spouse. In good faith, I believe she qualifies based on my spending 3.5 hours with her Labor Day, yesterday, as well as the other 4 times that I've met with her. I have not spoken to Mr. Cordelia, but I believe that was probably going to be where he was going to go. I was not, involved. I believe you were involved at that time. Or may have been.
Not me.
Okay.
My predecessor was.
But I think it was always ready to go. And for whatever reason, he withdrew at the last moment. And then here we are. But
Not for whatever reason.
I
For
think
your
it's
client.
prejudicial if we're not allowed to present the defense that we believe we have a viable claim, and I would respectfully ask. I'm not asking for, I think most times you come on a homicide case, you would need at least 6 months. I'm asking for 1 trial cycle, 2 trial cycles, sometime at the end of the year or first of next year. I can be ready. I think that will give enough time for our experts to visit with Ms. Boone and formulate their opinions. I'm sure the state's going to want to take a deposition. I think they may have a right to hire their own forensic expert to go out and interview to see if they agree. But that's just going to take a little bit of time, Judge. I'm thinking 2 or 3 months, and we'll be ready to go. I'm not asking for a long continuance. The good thing about it is Mr. Cordelia has done a lot of work. My understanding he's taken just about all the depositions. I believe they've been transcribed. I haven't gone through all the discovery. She's got the 2 banker's boxes. She has not gone through all the discovery. We tried, but we have not made it. My understanding is a lot of the 2-hour interrogation with the Sheriff's Department has been transcribed. I haven't reviewed that, but we do have a problem with that interrogation. Now, that's why I made the request about the policy. Our policy in my county, San Jose County, is a little bit different. Based on my discussions with her, we feel like I'm going to need to file some motions relating to that. So, because of that, but ultimately because, yes, could I be ready for trial on October 7th? I believe I could, but not without the battered spouse defense, because I don't believe my experts would be ready. And so that's instrumental in our defense.
State, do you have any position?
I guess the state would just respond to a few things. Part of this battered spouse defense has been previously investigated with several Ms. Boone's previous attorneys, and in fact, the state did retain an expert, Dr. Tanya Warner, who's on the state's witness list in this case, in anticipation of a potential rebuttal of an attempted battered spouse defense. The state's position would be that we would oppose a continuance at this time. However, the state's not opposed to setting another status hearing sometime next week, possibly, where we could address this and to see if there has been any movement, anything that would either change the state's position or potentially the court's position as well.
I don't think the state's thinking it through, Judge, because if we wait a week, I've got to file a notice.
So we know he has chutzpah because he just said on the record, I don't think the state is thinking it through, Judge, which to me translates to have a what? So, okay. He's on his toes. He's paying attention.
Intent to rely on battered spouse on Monday. We can't wait a week that the time is expired if the judge doesn't continue it today. He wants to have a conference next week, but it's too late for him.
What's your response to the rule requiring these battered spouse or battered wife syndrome defense 30 days prior to trial?
You have to give it.
Right, but I mean, clearly when that rule was created, it contemplated that there would be sufficient time to prepare for that defense within 30 days of trial, which is why they gave 30 days, which is why the Florida Supreme Court said that 30 days, not 60, not 90, not 120.
But in good faith, you can't file a notice of intent to rely on the defense of battered spouse syndrome if you don't have a supporting psychiatrist, forensic psychiatrist, that makes that claim. I just can't say, hey, we're going to rely on it, and I'm putting you on notice. I've got to have some kind of authority. I'm not an expert. I think she meets the criteria, but I'm not a psychiatrist. I'm not a psychologist. I can't make that opinion. I've got to have an opinion from an expert before I can follow that in good faith. I can't do it without Dr. Harper. She needs more time. Dr. Brannon needs more time.
All right, thank you. State anything else?
No,
All right, thank you very much. All right, Mr. Owens, it seems like you've already started diving into the case and what the court file has reflected. So clearly you've reviewed what is in the court file and the history of this case.
Yes.
I'm sure you've read the court's June 28th order, which was extensive as to the history of this case, multiple lawyers that Ms. Boone has gone through, the reasons for the non-conflicted out lawyers' basis for withdrawal, and why the court ultimately made a decision that Ms. Boone had forfeited her right to court-appointed counsel by her actions, or alternatively waived her right to court-appointed counsel by virtue of her actions. This case has been pending for some time. You advised in your motion to continue that you met with Ms. Boone on 4 different occasions, that you just met with her yesterday for 2.5 hours. You were aware of what the order identified, which was in paragraph 6 of the order in the judge portion, that trial specially set for October 7th, 2024, and that would be not continued for any reason, have such extraordinarily good cause, and such extraordinarily good cause would not include the retention of counsel. You haven't been appointed in this case. When you undertook this assignment knowing that you were not being appointed and that by your own representation you're doing this free of charge on a pro bono basis and not seeking recompensation for any lodging or travel. You knew what the deadlines were for the court. With regard to any of the experts, there have been multiple prior experts in this case. You already identified Dr. Julie Harper, a forensic psychologist. You advised that she's met with the defendant on 6 different occasions. She was appointed back on August 3 of 2020 under Mr. Padilla's representation of Ms. Boone. At no point in time did Mr. Padilla file a Category A witness list disclosing Ms. Dr. Harper as a testifying expert, and as you astutely pointed out, this matter was days, if not weeks, away from being tried when Mr. Padilla moved to withdraw based on the reasons outlined in the court's June 28th order. Thereafter, Dr.
So just really quick, even though Mauricio Padilla had engaged Julie Harper, he did not, and he's pointing out that the attorney Owens already said Padilla was weeks from trial. He never submitted Padilla anything from Ms. Owens to be an expert in battered spouse defense, nor did he file that 30-day notice that's required if you are going to present a battered spouse defense. So there's a gap there. Either Ms. Harper was not down with it, or Padilla decided to go another way. I think that's why he's trying to call Padilla. And I'll show you the video of what Bannon has to say, like I said, after we get through this.
Dr. Charles Heller, another forensic psychologist, was appointed on February 3rd, 2022, and again on March 1, 2022. No Category A witness list was ever disclosed with regard to Mr. Heller. Then Winston Hobson had an undisclosed expert that had met with Ms. Boone, as addressed in open court on February 9, 2024. And as Mr. Hobson put it, that expert was not meeting with what Ms. Boone had desired or requested of that expert. There was another expert psychologist that was appointed by Patricia Cashman on February 28, 2024, who has expertise in battered spouse and or battered wife syndrome. There were also Dr. Linda Dore, 2 times sought to be appointed, once by Attorney Bankowitz. Dr. Dore specializes in battered wife or battered spouse syndrome. Once by Dr. Bankowitz Mr. Bankowitz, on July 17, 2023, again by Attorney Hobson on January 1, 2024. Based on the Florida Supreme Court decisions in Middleton versus State, 220 Southern 3rd 1152 and 1176, Barlow v. State, 221 Southern 3rd 562 at 569, there's a 2-part test determining the need of experts. We're not going to be addressing that today, as you sought to file these other motions that I haven't had really the opportunity to address. And JCS is not here to have the opportunity to review those. In Ramos versus State, 75 Southern 3rd, 1277, and pinpoint 1281, by the Florida 4th DCA 2011, citing to Lawson v. State, 884 Southern 2nd, 540, also by the Florida 4th DCA in 2004. In that case, defendant Ramos changed his defense counsel at least 4 times while this case was pending, with the latest change of counsel occurring 2 to 3 months before the actual trial date. There's no record evidence showing that any of Ramos's previous attorneys had provided ineffective assistance, and the defense had already moved for 4 continuances to prepare for trial. Similar to the Ramos case, Ms. Boone has played a prominent role in shortening the preparation time for trial, as set forth in the court's June 28th order. This case has already been continued 16 times. As of the date of your filing of your notice of appearance on August 30th, this case has been pending for 4 years, 6 months, and 4 days. On June 7th, this case was specifically set for trial on October 7th, and the June 28th order by the court specifically speaks for itself and evidences how Ms. Boone played a prominent role in shortening the time for preparation for trial when her 8th attorney, Ms. Cashman, withdrew. Ms. Boone reached the point where her right to adequate time for preparation and trial is counterbalanced by the right to the effective administration of justice. As of August 30th, when the notice of appearance was filed, there were 37 days until trial commencing in this matter. Considering the prejudice of the denial, Ms. Boone has already availed herself to 4 different attorneys that were not conflicted out, Padilla, Bankwitz, Hobson, and Cashman, and only has herself to blame for the withdrawal of those 4 attorneys based on the representations in those motions and the findings in the court's June 28th order. Discovery has been reviewed with Ms. Boone by prior counsels, as established by counsel's representations in various hearings, and prior counsel's motions for attorney's fees, all of which were filed in the month of August of 2024. Ms. Boone has had discovery in her possession since August 5, 2024. The digital discovery that the state seeks to admit at trial was provided to Ms. Boone on August 9. Although you are not court appointed, sir, the court's done its own research with regard to your expertise. You've been barred since October 15, 1986, with a duly elected public defender of the First Judicial Circuit in the state of Florida. From 2009 to 2012, you've tried over 100 cases to verdict throughout your career. You've met with Ms. Boone on 4 occasions, as outlined in your motion, not including the meeting that you had with Ms. Boone yesterday.
So he is reading out his CV, and he's got the chops. Over 100 cases taken to trial, so he knows how to voir dire a jury, an opening statement, a closing argument, cross-exam. He's putting it all on the record. Judge Koenig, I'm in love. This is very clear. I won't say if it goes to appeal. I'm sure she's going to file an appeal either way, but on making it very clear about what decisions he made and why, which is the only thing that is appealable, right? Is there has to be a trial court error, and he's locking it up tight.
As to the battered spouse syndrome defense, you still have time to file the appropriate notice in accordance with the rule. And considering all the factors as set forth in terms of the state 311 Southern 3rd 185 and 189, Florida 2nd DCA 2020, your motion for continuance is denied. This trial is still set for October 7th. We will have pre-trial the 6th to 27th. Pre-trial in this matter, or trial case management was supposed to be set for September 26th at 9 a.m.
Judge, a couple of things. Number one, I have a full practice. I've got a docket day this afternoon in Santa Rosa County before Circuit Judge Scott Duncan. I've got 12 clients that are pending. I've got other people covered, but I do have a full docket. If we set some of these hearings involving my motions, could I be allowed to hear by Zoom?
Any objection?
No, Your Honor.
The only request I would have, sir, is the rules of general practice require a notice regarding your appearance. If you could just file a motion, then provide a form order, I'll sign it, and you can appear virtually. There's no reason for you to drive all the way down from Santa Rosa County for all these hearings when we can appear virtually. JACS, I imagine, will be appearing virtually for some of these motions with regard to the experts. So as long as you file a notice in advance, sir, I've got no problems with that.
Judge, in that pre-trial order, it mentioned, I thought, that the state attorney was supposed to meet with the defendant and the defendant's investigator and review all the digital evidence from the order. That's the way I read it. They were supposed to sit there all together and watch every potential video exhibit the state was going to intend to introduce at trial. That has not happened. I think today was the deadline for that. I don't mind extending that because I'm going to need to look at the evidence.
With regard to the digital, the deadline, you are correct, sir. The deadline was today, based on the August 5 order. If it did not happen before then, as I outlined at the beginning, there was a change to that process. A thumb drive was provided in open court to Mr. Lane on August 9. He then provided it to Ms. Boone, a thumb drive of the specific digital evidence that the state is seeking to admit at trial, based on the witness and exhibit list that was filed under seal on August 9. Ms. Boone had the opportunity to review that information at that time.
All right, I'm going to ask for more time for me to review the digital.
So see, Sarah led him astray on that one because the August 14th hearing, she confirmed that she got the USB with the 9 digital pieces of evidence that the state wanted to enter, and she had only looked at one with Mr. Lane after the judge asked her, and she said, we have other things on our to-do list. And that's when I started watching the docket to see if she ever filed her objection to it, just to confirm that she had at least looked at it, I find it interesting because they talked about that multiple times, and he's saying that's not the way he understood it. But in order for him to stand up and say the state hasn't done that, he's had a conversation with Sarah about it. And I feel, per usual, she just gave him bits of the truth, like what she did with the boxes of like, oh, I have a drawer. Oh, there's a whole property thing, not connecting all the dots and letting it be alluded to that those things are available. So if he asked her, for example, hey, they were supposed to do this by this date, have you done that? She probably just said no, instead of saying, oh, that was changed in a subsequent order and I was given those 9 files on a USB and meant to review them. Do you know what I mean? He's gonna learn, but I'm glad that at least he's believing in her, so that's going to build trust, and then he's gonna have to get to the stage of trust but verify. I also think this is good because I believe she tried this with Cashman based on her wanting to see her medical records and the like, and saying information was missing, and Cashman was like, we're not going down that road, I'm not revisiting this, because she's saying the same thing to him and he's putting it before the judge. So he's not telling her no. The judge is telling her no, right? So that still keeps their relationship intact. Where I'm saying both of these lawyers are both very experienced. Oh, hang on one second. Here goes my food order. Okay, so the delivery guy did not follow instructions. So dogs are up, babies up. But both of these lawyers are experienced lawyers, both Cashman and Owens, right? I think Cashman said she had 40 years experience. I don't know. Let's see. He passed the bar in 86. It's got to be, yeah, he's got over. Well, my math is not mathing right now. It's 11:34 at night. but they both have a lot of experience. They have a different approach with the client, right? Even though Cashman had a reputation for handling difficult clients, she may have been fed up with Boone after Boone walking out. And, who knows what Boone said to her face if she told us that she was snotty and needs to smile more and didn't like her and was prejudiced. You know what I mean? So instead of him saying, I'm not going to pursue that, he's saying, let's let it unfold, which I often do at work. Because sometimes just telling people no, they'll be like, oh, you're always negative, or you're just let it play out at the end of the day. So we'll see. Again, Julie Harper has already seen her. Julie Harper did not come back with the battered spouse. She's going to see Julie again. And also Sarah is seeing a therapist, is coming to see her. I'll have that as soon as we finish. We're almost done with this, so I'll try to stop interrupting. I just want to give you my thoughts, my 2 cents. That's why you're here, right?
Exhibits they intend to introduce. I don't know if they've been redacted. I don't know if they're the originals, but I'm gonna need to look at that. I went to the jail yesterday. I had to let them know in advance that I was coming. I believe my secretary had emailed them and said I wanted to bring in my laptop and my phone to view evidence and whatnot. I was not allowed to bring in my laptop and phone yesterday for 3.5 hours. So I didn't get done a lot of the things that I wanted to get done within that period of time. Probably would have stayed there a lot longer if I would have had that capability. So I would ask for some more time to be able to for me to look through the digital evidence as to what I assume is being redacted. I know some of the audio in terms of clients, comments the client made, comments the officers made, some of it is, in my opinion, improper to be presented before the jury. So I'd like some extra time to be able to do that.
State.
I'm not certain, is he asking for a continuous again? What is the extra time that,
So I think some of the things he wants to redact, like when she threw Eli under the bus about Eli not being not here legally in the United States, and some of those other things, and then whatever conversation they were having about using the toilet, and Kim and was it Kim and Eli? No, I don't remember, but I think all of that. And I mean, probably not probative, probably more prejudicial, right? There might be some Latinos on the jury that are not going to view that as favorable. So yeah, and we've already got neighbors, audio testimony where we know the neighbors not really friendly with them.
that he's seeking?
What is it you're asking for? Extra time to do what?
The way I understand the order, I'm looking at paragraph 4 of the scheduling order and notice of hearings that, Judge, you signed August the 5th. Paragraph 4, the state's digital evidence will be reviewed with the state's investigator, the defendant's investigator, no later than September 3rd, 2024. This evidence viewing can be done in advance of September 3rd deadline. The state shall provide the defendant USB drive with station. They never viewed it with my client in its entirety. As the order states, they were to do by today. So the state attorney has failed to comply with the court's order.
That's not
I'm
true.
saying I haven't had a chance to view it either. Can we reset that deadline?
Now you see, Mr. Secretary doesn't interrupt. Judge says, give me a moment. They both sit down. What he just said is not true. That there's a subsequent order on that.
Mr. Owens, we had a different hearing. And at that hearing, we addressed the digital discovery review. Mr. Lang was here. There was a USB provided in open court. And the August 9 order and notice of hearing identifies a change to that August 5 order. Specifically in paragraph 4, prison break investigations by and through investigator Billy Lane shall take possession and custody of the USB jump drive, which contains the state's digital evidence, tendered in open court on August 9, 2024, and shall provide same to Major Malik X. Muhammad at the Orange County Jail today, August 9. Paragraph 6, prison break investigation shall file with court a notice reflecting that the discovery in the USB jump drive, which contains the state digital evidence, was provided to Major Malik X. Muhammad at the Orange County Jail, including the date and time of the transfer. Such a notice was provided by Mr. Lane and filed in the court file. It was discussed at that August 9 hearing as to the revising of the digital evidence schedule. Paragraph 8 states that on August 14th, 2024, 1:30 p.m. a hearing will be held, courtroom 12A, regarding defendant's review of USB jump drive, which contains the state's digital evidence. The defendant's August 7th letter to the court, provided to the court on August 9, and the media's participation in the physical evidence viewing on September 3, 2024, the pertinent case law is attached. On August 14th, we had a hearing, we discussed that, and we identified that she had the deadline until August 23rd to make any objections. Now, under the original scheduling order, which said this matters, which on August 5, which set the schedule for when there would be deadlines for objections, those would be extended by good cause shown. Are you seeking at this point in time to extend the deadline for a period for objections which has since expired?
Yes.
Okay, state?
No.
Okay. How much time would you like, sir, in order to review the state's digital evidence that it seeks to admit into evidence and tender any objections?
I've got to go buy a jump drive. I've got to take it down to his office. He's going to give me that evidence.
So that is why I believe that Sarah misled him, because he said it twice, right? Full-throated. It wasn't, he didn't hesitate. Now, granted, I don't know him. This, as they would say, is his baseline. It's my first time seeing him, so I'm going to have to say yes. So presuming that he's, honest and forthright, I don't believe he would have been so full-throated, because he specifically said the state has not met their deadline, right? He didn't say, I don't believe the state has met it, or to my understanding, they haven't met it, or my client conveyed to me. He just straight out said the state has not met their deadline. So I think he got it from Sarah. Whether it was explicit or implied, she led him to believe that that hasn't happened, even though she said in open court. And that's where he's got to trust but verify, because we have that on the record. Mr. Lane went that day, August 9th. I believe the hearing was at 8:30, 9 o'clock, whatever. It was a morning hearing. And at 11:35, he had sent that USB taken it to the jail, given it to that Mohammed gentleman. How do I know? Because then he filed the same day, confirming that he did it and confirming the time that it was done. And then on August 14th, that next Wednesday, the judge asked her, did you receive it? Yes. Have you had a chance to look at it? Well, I have it. And she went round and round. So then the judge clarified, how many of the 9 files have you and Mr. Lane looked at? And she was quiet for a while. And then she said, I think she said almost 1, which didn't make sense, but she was soft spoken. So I'm not sure, but I know it was no more than 1. Whether it was half or full, it was 1. And so yeah, she has it. She said it in court that she had it, that she received it, that she didn't go through all of them, but she had the USB. So whatever happened in their conversation, maybe he misunderstood, but he seems pretty sharp. My money is on Sarah not fully disclosing, because we know that to be part of her history.
Obviously, I need to review it with my client. I've got a flight out of here around, I think, 4 o'clock. I don't know if I can get it done by then, but I don't see the necessity of an issue maybe a week prior to trial. Whatever that is, a week prior to that Monday, October the 7th, the week prior.
State?
I'm going to be amenable to setting a status hearing that week.
Here's what we're going to do. We'll address any objections to any of the discovery when we have trial case management on the 26th.
Thank you, Judge.
All right. Anything else, Attorney Owens?
Give me 1 minute.
Sure.
'26 is a little bit more than a week. A week from the 26th to October 3rd.
Not this time,
Madam Clerk is going to work dutifully to, it's already done? Excellent. I'll have Ms. Barrios, my judicial assistant, forward these to JCS and see if we can coordinate a hearing. State will have till close of business September 10th to file responses to motion for statement of particulars and motion for additional discovery. Parties having no business before the court. You'll have a fabulous day.
Thank you, Judge.
Thanks, sir.
Can I have a word with Sarah?
Absolutely.
We cut the audio. She went to get the pin from her. Oh, sorry, guys. There we go. And she's walking out. So overall, I like him. I like his approach with Sarah. I think, it's important that he's been able to build rapport and build trust. At the end, when her things got denied, she looked sick and she looks guilty also, like when the judge was saying, no, that's not true. Because I feel like that's her way to acknowledge of like, oh, I didn't tell him everything. I could be all just making it up. These are my opinions. I like to read people. I like to people watch and people study. I went to a different school every year until I got to high school. So I feel like I'm pretty good at like figuring out folks, just as a matter of my own survival. So that was there. Then I want to, let me think here, because I have a lot actually to show you. Let's go to outside of the courthouse immediately after. Actually, no, let's go to the good doctor. Make sure I'm sharing with you guys, unlike the last seconds of the other clip where I was not sharing. Oh, goodness gracious. Okay. I want it the other way. There we go.
Actually corroborate her battered spouse syndrome defense. Dr. Michael Brannon, this is where I want to bring you in. We all saw you testify in Marsha Thompson's case, and you were really the star of that trial, the breakout star of that trial. Your expertise really shined. Looking at this case, and I know you haven't personally evaluated Sarah Boone, but based on what you know and the facts we see them, do you think she could be successful on a battered spouse syndrome defense?
Well, good morning, Julie, and Melba too. Good morning. So it's a very difficult defense, even when everything is all put together nicely for the defense to occur. And there has to be a number of different elements that fit in order for the battered spouse defense to be successful. And in this particular case, there's a reason why people go through a lot of different attorneys. Some of them may just be stall tactics. Some may be trying to establish a certain defense. But attorneys may be, and again, I didn't talk with her, I don't know that much about the case, but attorneys may have already told her, listen, you don't meet the elements of this, or this is not going to be successful, trying to give her the benefit of their legal knowledge and background. And she may not have been willing to accept that. She may have heard from other inmates or family members, or she may have seen court TV and thinks it may be a good idea, but the facts of that, the elements may not apply directly to her case.
Appreciate that, Dr. Brannon. We knew in one of the motions that.
So that is the doctor that Attorney Owens was calling this weekend, trying to get on the phone to talk to him about coming onto the case. I think this doctor already knew he was booked for court TV for the, first day of the week. I know it's Tuesday, but Monday was a holiday. Because just like you and I talked about this on Friday, like at 11 o'clock, I saw it on the docket, I'm sure. And this isn't my job, right? This is just me being nosy. I'm sure Court TV probably has a little alert of when things get posted. And so they knew he filed well, I don't know about the notice, but they knew he filed the motion to continue, and they read through it where he said the battered spouse syndrome is what they wanted to pursue. So I'm sure they booked this guy on Friday. And so the weekend while Owens was calling him, I'm sure he has caller ID. He was like, mm-mm. So he was saying that about the battered spouse syndrome, right? So I'm a fan of Chat GPT. And so I pulled up this because we talked about on Friday, I think we talked about the second degree. What were the requirements for second degree, or on Saturday, some other day than today. And so I want to let's look through this together, what I did with ChatGPT. Can you guys, let me see, make sure I'm sharing. I'm getting the hang of it, I think. Well, spoke too soon. Here we go. Oh, that's tiny. And it's late, so my Mac has gone into night mode. So in Florida, battered spouse syndrome is considered a form of defense in criminal cases, particularly in situations where a person may be charged with a crime related to self-defense or defense of others. While there isn't a specific statutory criteria for battered spouse syndrome, it generally involves the following key elements. Pattern of abuse. The individual must demonstrate a history of abuse or violence from the abuser. This pattern of abuse should be documented through evidence such as medical records, police reports, or witness testimony, right? So he said he wanted to get her medical records for when she was stabbed in the ankle, foot, leg, police reports of all the incidents, which I don't know. I think I reached out to the state records and they didn't have all the police reports anymore, but they said I could reach out to the sheriff's department or the arresting agency, and I didn't do that. So hopefully he can get those, because the other one is beyond their like record keeping protocol. 2018 is too far back for them. Or witness testimony. So he referenced the people in the apartments in the complex. And so maybe, they saw things, have videos of things. So he talked about all of that and getting those records and having the private investigator get those records for those witnesses. But they have, the Sexton woman, Melissa Sexton, the apartment manager or property manager. They have her because she's a witness for the state. They have the next door neighbors that were upstairs and downstairs to the one side of Sarah and George, and then Eli and Kim, whoever they are. You know what I mean? So there are definitely witnesses. So I think also that's why she was trying to get her phone to get those contacts. But again, Billy Lane. Psychological impact. The syndrome involves psychological trauma resulting from the prolonged abuse. This may include symptoms of post-traumatic stress disorder or other emotional and psychological conditions. So this is going to be interesting because there's, I think, if I remember correctly from the Amber Heard and Johnny Depp trial, like she did not meet the criteria of PTSD according to the plaintiffs expert, right? They were saying like she was malingering, and so like faking it or speaking as if she had it but she didn't really have it. Like her answers indicated that she was pretending to have it, I guess, is a more concise way to say it. So yeah, so that one is going to be tough to fake, is a long way of saying that. Reasonable perception of threat. The individual must show that at the time of the incident, they had a reasonable perception of imminent danger or harm from their abuser. So we looked at that video the last time we were together, and I didn't see imminent danger. This perception is often influenced by the history of abuse and the ongoing threat. So I think this is what he's referencing the Dr. Bannon for. Perception is often influenced by the history. So maybe in that moment, although you and I don't perceive that she is in imminent danger, but maybe because of their history, that is why she perceived that she was in imminent danger. I'm curious about this history, that would be imminent danger. A man in a suitcase telling you he can't breathe. So yeah, and if that was an ongoing threat, because when you put him in there, what was your plan to get him out? You know what I mean? If you were in imminent danger, you could have called the police. You went to sleep. I don't know that I would go upstairs and go to sleep if I were in imminent danger, but again, I'm not claiming battered spouse, so I have a different perception. And I think that is a way to also get to the jury of like, you may not have experienced this trauma and you may see it a different way because you haven't experienced this trauma, right? So kind of like mitigating for her, a mitigating factor. Proportional response. In the context of a legal defense, the response or action taken by the individual must be proportionate to the threat they perceive. This means that while the individual may have acted in self-defense, their action should be evaluated in light of the ongoing threat they faced. So if someone is, I don't know, coming after you with a knife, don't shoot a gun. I'm just trying to think of what might be. But in this case, it was so subdued, right? It was like torture before death. Someone in one of the chats earlier was saying it's sort of like Shonda Vander Ark. Like you don't intend to kill your victim because you're taking pleasure in the torture and it's like ongoing torture. Sarah had all the control in this relationship. She had the apartment, she had him removed from the lease, she had the car. He didn't have a license, but Melissa said he was driving the car on a regular basis. He was dependent on her for money. I'm sure, well, I'm not sure. I would assume he was getting unemployment because he had only lost his job, according to the maintenance man, a few weeks before. But that part doesn't really make sense to me because he already had to get rid of his phone. Like, it, I don't know. Usually maybe they're living paycheck to paycheck. I don't know. Usually your bill cycle is like 30 days. You'd have to be at least 30 days late before they would cut your phone off. So that was a little confused. I mean, maybe he had a prepaid. I don't know. I don't know what his financial circumstances were. But Sarah had all of the control as far as like money, housing, transportation, right? And so she could have just called the police and had him removed, is what I'm saying. Like, yeah. In legal cases, evidence and expert testimony, such as from psychologists or counselors who can speak to the psychological impact of the abuse, are often crucial in establishing the presence of battered spouse syndrome. So then, let's see, I'm going to do his interview last, if you're wondering. So if you're in a hurry, you could skip to the end. I just want to go through her. So nosy me, I asked for her visitor logs, and these are video visits. There's two kind of logs. So these indicate that it was video, and they log everything as it comes in through the visitation center. Let me make sure I'm sharing this. Where are you guys? Let me make that bigger. That looks tiny. Okay. I'm trying to go slow. I know some of you guys gave the feedback that I go too fast with the sharing, and it, ooh, excuse me, that I go too fast with the sharing and it makes you dizzy. Okay, hopefully we can see that together. So this is back when she still had Winston Hobson, who we know he was going for battered spouse. So this visitor, because it's a professional, you know, I had to be nosy. So this person was at home. It was an internet video visit where she was, where the station was. The visitor's name is Jody Rabkin Turner, right? So she, on this occasion, was a no-show on the 4th of February. So I'm assuming, if anybody's been in this show or work for this show, let us know. But I'm assuming it's booked in advance, sort of like a teleconference, I'm thinking, like a teleconference room, and then this woman didn't show up. So here we have the visitation time. You see how it says up here, February 5, 10:30 to 11. So it was booked. And she checked in at 10:19, so she was early. It doesn't have the checkout time. But again, it's the Jody Rabkin Turner. I don't know why they didn't capital. I also have a hyphenated name, and sometimes they don't get the capitalization right. Like, anyway, that's a whole other personal tangent that I don't need to go on. 2:15, no show. Again, it's Jody. Their time was 3:30 to 3:45, so 15 minutes on the 15th in 2024, in this year, February. And then it looks like they rebooked for the same date at 7 to 7:15, and again, no show. So then we go to 2:20 and the 10 to 10:15 meeting. Here, the check-in time was 9:51 with Jody Rabkin Turner. Those are friends. And it's nice to see Brian and Lucas. They're still visiting as late as March. I didn't see anything past March, though, but he hung in there with her. I mean, I guess Lucas wanted to see her, and he can't do it by himself. Okay, so that is this one. I'm going to show you one more. Let me also make this one larger. So this is later in 2024, right? We've got Jody on the 4th of July, scheduled from 12:30 to 12:38, 8 minutes. I don't know what was happening. But and then she checked in at 12:22. So I'm hoping when she checks in that Sarah's there so they get a little more time, but maybe not. The guards might not really. This I'm looking into, this Christina M. Pena, because I think she's an ex-inmate. She's on some of the behavior reports, and Sarah was using her locker to store her locker and her bunk to store extra stuff, and now I see her on these visitor logs in 2024. But I have to do more research on that. So here on August the 4th, so the month we just left, she checks in 11:48 for a 12 to 12:05 visitation time. That is just strange to me. But again, maybe they talked from 11:48 until 12:05. Sarah McDermott, investigator. I don't know. Maybe she's with Prison Break. That's a whole other rabbit hole to go down. Okay, so who is Jody? When I Googled her, she came up on ZocDoc as a psychotherapist in Florida. Jody Rabkin Turner, licensed mental health counselor, accepts 70 insurances, works at Rula Health in Florida, speaks English, offers telehealth visits, 5-star rating. Julie was very attentive, made me feel, now granted there's 2 reviews, but still 5 stars. That's hard for a mental health counselor. Like, that's hard. She's been working for 25 years, helped countless clients learn about and work on their core issues of depression and anxiety, and have extensive experience with substance abuse issues. I also work with clients dealing with abandonment and issues due to childhood and recent traumas, which she may have abandonment issues because her father died early, like when she was young. That can create abandonment issues. Including grief and loss issues. I specialize in trauma, addiction, codependency. She's definitely codependent with Brian. Abuse, domestic, it says vice, I'm assuming violence, and family issues. I use processing trauma and past issues as my main form of work, including hypnotherapy. I use cognitive behavioral and psychoanalytical perspectives, which help with when helping clients. So I do cognitive behavioral therapy, like as the patient, I'm not a therapist. CBT, which basically we look into my past, and the therapist helps me understand like how my past trauma impacts my current perception, and trying to like rewire that part of my brain. Psychoanalytical perspectives when helping clients. I'm a licensed mental health counselor in Florida, licensed professional counselor in Colorado, certified hypnotherapist, master level certified addiction professional, and master addiction counselor. So hopefully, I don't know, they haven't entered it, but that would be a good thing. I'm glad that she's getting some kind of help. They also have, I believe, like an AA, like a 12-step type program in most jails. BA in psychology from SUNY Stony Brook, so somewhere in New York. MSED, major in counseling with distinction from Hofstra University in New York. I've also taken updated counseling courses at FAU. I tend to break through surface level issues and get to the core issues a person has to promote change and well-being in the individual. People tend to open up to me due to my empathy and understanding of trauma and its effects on their behaviors. So I don't hold it against anybody for getting therapy. I believe in therapy. I think therapy is a good thing. And even if Sarah did a bad thing, it doesn't mean because of her behavior she's a bad person. I'm not saying she's a great person. I'm just saying, or I'm not saying, first of all, let me just say, like, I love that we voice our opinions on here. I like to look at both sides of everything. I don't ever want to be like in an echo chamber where everybody I talk to thinks the same way I do, because I like diversity of thought. I think when people play devil's advocate, it just deepens my perspective on things, because either I can be swayed or I'm like, oh, I haven't considered that. Do you know what I mean? So it kind of helps, I don't know, just either reinforce or break down some of the things going on in my head, which I think is a good thing. So anyway, that's my little okay, I'm gonna look at these other tabs really fast because I feel like I'm gonna close that one. I don't want to show you guys anything from here.
It's a gap in the system that hardly ever happens.
Case,
Excuse me?
why this case?
Sarah Boone needed a lawyer. I mean, I can't imagine our system. The case is an aberration. Okay, this just a gap in the system that hardly ever happens. You know, at the federal level, on the state level, everybody charged with a crime is entitled to counsel. Everybody, never, unless the client, unless the defendant waives their right and wants to represent themselves, which is rare and foolish. But I understand the judge's ruling. We respect the judge's ruling. But that left Sarah in a position where she's standing in a courtroom accused of murder without a lawyer. I can't think of any other time that you would need one than in that scenario. So once that decision was made by the court, Sarah put an ad out. Somehow it got on court TV. I watch a lot of YouTube, true crime. I saw it. I didn't immediately act on it. I waited 3 or 4 weeks thinking that one of the members of the defense bar here in Orlando would pick up the torch. 3 or 4 weeks went by. It did not happen. That I was genuine. Then Sarah called me and we talked on the phone a couple of times. Hillsborough County in Tampa that I had to come down for. So I wrote her a letter about a week before that. And she had a third party, a girl from Minnesota, that reached out to me, I think first just to see if I was legitimate. They said to see if I was, I think catfishing is what they call it.
So the girl in the chat you guys told me about, or the woman, was she from Minnesota?
Once the third party realized that I was genuine, then Sarah called me. And we talked on the phone a couple of times, and I said, hey, I'm coming down that Wednesday for that court case in Tampa. Why don't I just come down Monday, which I did. I got done with court, I think Monday at noon. I drove down 6 hours, spent the night, got up the next morning. I think that was on the 20th. And I spent about 4 hours with Sarah Boone at the Orange County Jail. During that period of time, I was in talks with the prosecutor, let him know what I was doing. He wanted me to file a notice of appearance. I wasn't ready to make that commitment yet. Didn't do that, but I got Sarah to sign a document essentially saying, you know, you can speak to the prosecutor on my behalf. There was attempts to try to resolve it. If we would have come to terms, I would have filed a notice of appearance. We would have set it for court, set it for hearing, and the case would have been resolved. So we did make attempts like everybody does in every case. Any prosecutor, any criminal defense lawyer, public defender, you have plea negotiations. That's just part of it.
So he's already tried
So
the
there
plea
were attempts
negotiations.
to settle it. I was kind of like a mediator. You know, I was kind of like a go-between, because once she became pro se, it's very difficult for the prosecutor to then communicate with the defendant. Actually, the rules say you got to do it on the record. And you can imagine not having somebody to negotiate for you, and she's trying to negotiate with the prosecutor, trying to send her to prison for the rest of her life. So somebody had to do it. I was doing it. But after those, so I met with her that day. I went
It's
over
as
to
loud
Tampa,
as it'll
handled my
go.
case. I think I was done at 2:30. I came back. Well, Billy Lane, the investigator that's assisting Sarah Boone, pro se, he had scheduled an appointment to meet with Sarah that night. So I went back over to the jail. They let me meet with them. So the three of us met. This was, I think, the 21st, like it's set from 7 to 8:30. We met for about an hour and a half. And, you know, at that point, we couldn't reach an agreement. And then I wasn't ready to represent her at that point. I immediately told the prosecutor that there was an impasse. There was no agreement that I was not going to be representing her. I got in the car and drove back home. Got home about 4. I had court the next morning at 8:30. I was done with the case. I did the best I could. I want to say 2 nights later, my wife and I were home, and Sarah called, and we talked again. Of course, I was still thinking about it, what to do, and but I told Sarah I was not committed to doing it. That was on like the 23rd. Well, then that third party called a day or 2 later, and really nice lady that I really respect. We developed a relationship, and she asked me if I would go one more time. So I flew back down. We met again a couple of times. I can't remember the dates now, 25th and the 26th. But both meetings went well. And you got to understand, Sarah's been through 8 lawyers, so there's some trust issues. And on both sides, you know, I'm concerned, is she going to try to fire me, or we're going to have problems the same way, as you can imagine. But, you know, I like her. She likes me. We communicate well. I think we're both on the same page. And, you know, I spoke to my family, my wife, my daughter Sarah about it. Sarah's thinking about law school, so I got their blessing. I have, you know, some colleagues that I practice law with, a law group there in Milton. And obviously it's going to take some staff to pull something like this off, especially knowing that the judge, I was in hopes he was going to continue it and give me 2 or 3 months. He did not. So we've got about 30 days. So I'm going to have some help from the staff, but we're trying to assemble a team right now. I've got a couple of friends that are lawyers that have indicated they're going to help me. And what are friends for?
Are you doing it pro bono?
I've been retained. I'm not doing it pro bono.
Who's paying for it?
Sarah owes me. Sarah owes me.
Can you speak a little more to your plan for defense of the battered spouse syndrome?
Well, you know, I'm not an expert, but I don't know if we're going to be able to do that because we're time crunched now. As you know, I think y'all understand the rule now. We've only got till the 9th, which was today, the 3rd. We've got 6 days. So I'm going to try to pay for Dr. Julie Harper to fly down here later this week. She's actually from my area. The 2 experts that I had asked for, well, there's a 3rd one, but 2 of them are from my area. Dr. Harper's from Okaloosa County and Dr. Berkman's from Escambia County, but I've been in communication with Dr. Harper. I think I'm going to get her to fly down here later this week to meet with Sarah several times. Hopefully, at the end of those meetings, like I said, she's already met with her, but it was 2 years ago. She met with her 5 or 6 times. Hopefully, she's going to agree with me that she does suffer from battered spouse syndrome. And so then if she's able to give me that opinion by the end of this week, my intent is to file the notice with the court and the clerk of our intent to rely on that defense. And then we go from there. That's really all I can say. It's up to Dr. Harper, not me.
So you've got 6 days to do that. Now, barring a Matlock miracle and that doesn't occur, what is your other, I guess, plan of action?
Well, you know, Sarah's been sitting in jail for a while. She's looking for her day in court, and we all want justice to be served. You know, I'm a criminal defense lawyer. I've been doing it a long time. The state has the burden of proof. They have to prove their case. I know there's some strong evidence in the case, but there are some explanations. I'd rather not get into my other potential defenses, but we do have some defenses. They've got to convince the jury beyond a reasonable doubt. That's all I really want to say. You know, just like any other lawyer facing a trial on a criminal case, the state has the burden. We're going to test the state's evidence, and then we've got potentially a case to put on. But we'll see. We'll see what happens at the end of this week. It'll be interesting to see if we can utilize, because I do believe she meets the criteria just from everything that I have viewed in terms of Mr. Torres's prior arrest. I did want to say something else, but want to say something, but I'll wait for you.
We gotta move downstairs.
Okay.
Or, I mean, we can just wrap it up.
We can just wrap it up.
I did want to say this. The Torres brothers are viral.
Okay, I'm not gonna play that part if you guys want to see it. You can look for the video because he's going to say bad things about the victim, and I just feel like the Torres family has been victimized enough, and they're just seeking justice, you know? So I'm not going to further that because I feel like that's part of his press tour. I haven't seen yet what he said on Vinny's show tonight on Court TV. It's Vinny's first day back. So I watched him on a live. I saw the pretend judge in there and some other folks in his live on his personal YouTube channel. So I'm glad that he's back. I'll look forward to watching that. But yeah, so I like this guy overall. Well, I like him for Sarah. And he seems like a genuine person, you know. And although we can squabble about it, you have to remember, like, defense and prosecution, they go golfing together. Like, they're friends. You know what I mean? There's not animosity. He has a little bit of an outsider vibe. He's got the accent. It's kind of like the reverse of Rashbaum going to Tallahassee. You know, he doesn't quite fit in, but hopefully he'll find some people, or maybe the jury will find that hokiness, you know, warm and welcoming. So you never know. I just think overall it's good for her to have an attorney. She has rights, and so there may be things that she doesn't do or doesn't know because she's pro se, like asking for dismissal after the prosecution rests their case in chief. Like those things, you just want to have all of that procedural stuff down because a lot of it is all about procedure. And so he's listening to her. You can tell she felt heard. Now, I know you guys are going to say she felt that way with Hobson. I don't know if she ever felt that way with Cashman. You guys have a theory about Sarah Boone and women, which I can't really explore. But overall, I like him. I like his energy. I feel like he's going to be good for her. I like his approach to running through the things that she wants to. Do I think it's a fool's errand? Yes. I think he does too, though, now that I see him speaking, but he wants to have all of that on the record. He wants to go through the paces for Sarah. Again, because then the judge is telling her no. He's not saying, oh, I'm not going to do that. So he's giving that, you know, time and effort. He's going to have a team of people helping him. Like he said, he has a full docket. And the judge is like, you picked it. This is the date that you're going. So I just feel like everybody's going to rally around him. And I also think it's probably good that he's from outside, an outsider, even though he says he watches YouTube. He has a daughter named Sarah who also watches YouTube and is thinking about going to law school. If you're watching, hi, Sarah Owens. So yeah, I just think this is going to be good. I think it's going to be good. I think he is obviously zealously representing her. He asked for all the things, even though he had a 99% of not getting them. He went for it. He didn't tell himself no. I always respect that in somebody. Like, don't tell yourself no. You got to try it, and then you won't really know the outcome if you don't try it. So he's in 10 toes deep. I think today he learned, you know, trust but verify with Sarah. So he'll do that going forward. I'm sure he does not want to be in there standing in there accusing the state of not doing something when they actually have done it. You don't want to be loud and wrong multiple times, right? You just want it to be once. None at all if you can help it. But hey, we'll give him the once. Yeah, so what do you guys think? Like the whole thing with the doctor not calling him back, with Julie Harper returning but not prior evidence that she supported a battered spouse syndrome. It's interesting, right? It's interesting. I just think it'll be a fair fight now, and we won't be at home like wincing over technical errors or emotions and insanity. Like he's not going to get emotional. I mean, they might be passionate, but you know, it's not going to be that like angry thing when Sarah's like, what do you mean by over and above? And you know, those things, like it's going to be a legitimate trial and we're going to get a verdict fair and square. So I think that's fair for Sarah. I think that's fair for the Torreses. I think that's fair for our judicial system. So those are my 2 cents. Let me know about your 2 cents in the comments down below. I'll talk to you later. Don't forget to like, comment, and subscribe. I appreciate you. Toodles.